hearing is over. We had the witnesses here.
That's what I'm saying.
No, they didn't know about it.
Who's they? The state? Well, here's the thing. Are we on the? Are you on?
Let me go through.
All right.
Let's get started. We're here in the matter of Saber. 240-19676, 240-19677. State House President.
Sure, Judge. MJ Raciti, R-A-C-I-T-I, representing the state of Arizona. Ronnie Burns for the state.
Mr. Meyer.
What was the second one? I didn't get.
Burns.
Without an S.
Burn?
Mr. Myers is here representing himself, is that correct?
Yes, sir.
This is the staff hearing.
Can I, before we move forward, can I make a little statement about last week, just to get me on the record? Because I heard you guys is on the record about it.
Sure.
Right now?
Sure.
Thank you. So, as far as I'm concerned, I know that she said that she had nothing to do with it, but let's break this down, sir. And then we can only go by people at face value. You say you have nothing to do with it. You've been here 25 years, and I've talked to everybody in this building, everybody at the other courts. Normally, they let me do the. Normally, you do the hearing and then you get arrested.
Sure.
That's standard procedure, right?
I agree.
Okay, and so let's go over why I was arrested because it's relevant to the record in this case. So at the last hearing that you and I had with Matt Walker, he attempted to go on the record, to get this court, you, sir, to order me to not be able to make videos, to not talk about the case and do all this stuff on social media. You told him it's my First Amendment right. He's, as long as he doesn't, he told me watch, be careful because there's laws, don't go, keep it into the area of free speech. All right, cool. So what do? Matt Walker leaves here. He goes and gets an ex parte. I believe unlawfully, they made the same exact arguments they made to you, unsuccessfully. They went over to Superior Court and they convinced ex parte. They manipulated a judge at Superior Court to give him an injunction against harassment against me, okay? For leaving one voicemail on Matt Walker's voice. One voicemail, never met this lady, never talked to her in my life, left one voicemail, and I believe the state was deeply involved in this. It's Matt Walker. I'm not saying this woman sitting right here next to me, but I'm saying, remember now, they just brought her in. Remember, last hearing was Matt Walker, so stick with me here. So Matt Walker, you denied him all his, you said, as long as he doesn't break the law, right, cool. So they go over there, the judge over there, female judge, for the record, gets manipulated into believing that I'm harassing somebody who I've never met, left one phone call on their public mail, right, gives them the injunction. They claim that, okay, then they serve it, but they forget to serve. The server came to my thing, gave me the petition, and not the order. So on Thursday, the day before, because remember, this was on Tuesday. So Thursday the 17th, a process server comes to my house and is supposed to be serving me this injunction. Goes to my house, leaves just the petition, not the order. Next morning, it was in the afternoon, I went down to Superior Court myself, drove myself to Superior Court, and I said, I have an injunction, give it to me right now. Hand it to me, sign it, serve me. We did that. So on my way home, I drive past, the injunction said that I was not, did you go to U of A, sir?
Yeah.
So the law building, the Rogers Law Building, right? The law library building, right? So the injunction said I was not allowed to enter that building. Well, on the way home from serving myself the injunction that said I wasn't allowed to enter that building.
Your Honor, I don't want to do it.
Why is she interrupting me right at the most important part?
Your Honor,
Is this an objection?
Your
Then
Honor,
state objection. State objection.
Your Honor, the state is concerned that facts will be adduced at this moment in life, and I don't want him to incriminate himself.
I'm not worried about all that. I'm perfectly good. Thank you. Thanks for the free legal advice. Sit back down. And now, you should take your own legal advice and dismiss this case if you're worried. And so back to what I was saying. On my way home from getting the injunction, I drove past the university. You've issued injunctions in your 25 years. If you say you can't be within, so I drove past the university on my way home from Superior Court on Speedway. That was on Friday the 18th. So I come to your court on the 22nd. I walk in here and there's the SWAT teams waiting to arrest me for violating the injunction for driving past the building 115 feet away. So we couldn't have court last week because I drove past the law building 115 feet away in my car, never stopped moving, never got out of my car. And that's why the U of A arrested me. Why did they wait 5 days, sir, so the violation occurred on Friday the 18th. Why did they wait strategically till I was 9 a.m. at this thing? If I was out here harassing people, violating court orders, and they knew about it, why did they let me go out 5 days? Bad things can happen in 5 days, sir, Somebody's out there harassing and threatening. You can't just let this madman walk around for 5 days. Why was it strategically without your knowledge, without anybody's knowledge, executed on behalf of the prosecutor's wife as I walked into my evidentiary hearing where the police officers were going to have to go under oath and testify to the way the evidence and all that. Suddenly, and here's the most telling part, sir, and I'm waiting on the body. The arresting officer was not here. So if I wouldn't have got arrested, he wouldn't have been here. The other ones were, the witnesses were here, but not the arresting officer. See, so they can't say they didn't know when their main witness wasn't even here. And then, magically, 2 days before the hearing, we get a new prosecutor who's not the wife of the person accusing me and getting me arrested. They can't say that this wasn't coordinated, especially with you, sir. You've seen it all. You've seen it all. Why was their only goal, sir, was to stop me from that hearing, from putting that cop under the witness stand, under oath, and that's, look at the lengths they went to. I'm not going to be found guilty of the violation. I should have got due process, right? It's because it's alleged that I violated it, right? So, allegedly I violated it. They took me to jail for a civil thing that's the equivalent of missing jury duty. Literally, I wasn't a fugitive from murder. The FBI wouldn't even arrested me right there. They would have let me finish the hearing, you know what I'm saying? So for some reason, they're claiming, oh, we had nothing to do with it, when literally it involves the prosecutor's wife. And they went and got that because you wouldn't do it. You wouldn't issue the order. So they went and got Superior Court to get an injunction harassment and then said I violated it by driving past the building. Well, I drove past the building on the way here. Why weren't they here? You get what I'm saying? I drove past the building on the way to this hearing. So I'm expecting you to show up and arrest me in any minute. Do you get what I'm saying? It's hypocrisy. I can't drive down the road. And then now my evidentiary hearing, we're almost at 180 days. Look what it took me to get that evidentiary hearing. And so if this is not an evidentiary hearing, I'm filing a motion to dismiss, Rule 15 motion for sanctions. All their witnesses are going to be excluded. They missed 4 witness deadlines, sir. The one by under 15 by rule, they had to turn over their witness list by rule by the first pretrial, July 11th. They didn't. Also, I filed a disclosure request, so by 30 days from that, I filed that on June 9th. So they had till July 9th. So basically, they had to the first July 11th pretrial.
It's only audio.
They did not. We go into Cranshaw's courtroom.
I'll show you
I
some
say,
video.
Cranshaw, I filed a motion to compel.
No problem
on
doing
June,
that.
it's all in the record, sir. Motion to compel. After I kept asking him, I did the request, couple requests, timely thing. Now remember, I'm supposed to be incompetent too. I'm mentally ill and incompetent, but somehow I'm filing all these things in a timely manner, putting in these disclosure requests, put in the motion to compel. We go to the first pretrial. Judge Cranshaw compels them to give me the witness list by August 9th. That was on July 11th. Okay. August 9th comes and goes. I still don't have the witness list. We go to the hearing with Judge Mayhew. In the interim, after they didn't meet Cranshaw gives me the disclosure deadline. They failed to meet it. I filed a motion, a Rule 15 motion. It contained the word bullshit. It got stricken. So I filed the motion to compel. Cranshaw orders it. They don't follow it. I follow up by following my motion saying, hey, they didn't follow the order. It gets stricken for the word bullshit. We go to the hearing. She says, your things, we don't need to beat the dead horse from last time, but I go to the hearing. She says, your motion's being stricken. I said, for what? She kicked me out of court. Never got to put anything on the record that day. The only statement that was made on the record that day was by the state. They talked in the mic and they said, we have our witness list. We're just getting it coordinated. So they admitted on the record in Judge Mayhew's, they had their witness list. Now remember, they were already supposed to give it to me a month prior. So this is throughout the thing, I'm prompting, I'm saying, hey, I need that. Hey, I need that. I'm filing my motions. They're ignoring them. So Cranshaw gave them a deadline, they ignored it. At the August 23rd hearing, they came and said, we have our witness list. So I heard that because remember, I got kicked out of hearing. So I emailed Matt Walker for 9 straight days saying, well, you just said you had the witness list. Why don't I have it? Nothing. And all this is going to be in the Rule 15 motion that gets filed today because the sanctions are going to be all their witnesses are gone. And if you have no witnesses, you have no case. And so, if the glove don't fit, you know what I'm saying? And so, here we go now. We're at your hearing when we met, sir, at the last hearing. And I'm sitting there pounding the table saying, I need you to order them to release these witnesses. Because now this is the 4th time I'm having them, the witness list, ordered to be released. The most basic concept of a criminal prosecution, the witness list. And then, so you ordered it, right? They gave it to me that day by the end of the day. And guess what they gave me? They gave me a list containing the arresting officers and the 2 victims. They could have gave me that 4 or 5 months ago. And that's the point, sir. It wasn't like they were doing this deep dive investigation, still trying to see was there witnesses that we haven't gotten a hold of. You know the game. They literally This is so boilerplate, feet dragging obstructionism. That's all this is. To gain a tactical advantage, they waited 4 months to give me the witness list after I had to literally basically get myself in contempt to prove a point.
He wins.
That I've been telling them to put
This
this
case, he
and you know what they
wins.
responded by? Filing a motion saying I'm mentally ill. Not saying we made mistakes in this case. We didn't follow the rules of procedure. No, this guy's incompetent. And what they're really saying, sir, is you're incompetent because they're saying, you agreed with me, so if I'm incompetent, you must be incompetent, and you ordered this, and I was bound at the table saying, I need you to give an evidentiary hearing. I need you to order the witnesses. And they're saying, well, that guy's incompetent.
do it
He was
for
in there.
yourself.
But somehow the judge ordered the things I was asking for. But I'm mentally ill and incompetent. Well, I'm sitting here saying, you got a law degree. You've been here 30 years. What's your
That's
excuse?
my dog.
You were supposed to turn over the disclosure, Rule 15 disclosure, by the first pretrial, and I filed a motion to compel and all this, and you want to sit over there all high and mighty. You haven't done a single thing by the book in this case. And the first day I talked to this woman, it's come full circle. She told me she's not worried. She has absolute immunity. The first day I talked to this woman back in June at my arraignment, I called and said, who's the victim? She said, I'm not, and we had a little discussion. It's all, the whole world can listen on YouTube. She tells me, I'm not worried about you. I have absolute immunity. So I knew right then, and that's why I started filing. Sir, there's a motion to compel. That right there was ordered by Judge Cranshaw, then ordered by you. There's multiple times of them not providing me the witness list. So here we are, October 29th, and I've had the witness list for less than 30 days. So that's 5 months I did not have the witness list, and about 30 days I've had it. So how am I supposed to prepare for a case? And here's what's even funnier. They put a name on there. They put an officer on that list. They put on the list that the day you ordered them to do it, they gave me a list, and it has an officer on there that has a woman named Bates. Her name's not listed in a single thing from the date. It's not listed in the police reports, the supplements. Nothing they've given me included this police officer. So at the very least, she's not coming anywhere near this case because they disclosed her 5 months into it with no valid reason why they couldn't disclose it sooner. And that's my point, sir. The test is, in the case law is, I got it all right here. The test is, did they do it to gain a tactical advantage, okay? They clearly, I mean, in this case, State X Berger versus Maricopa County, they literally said, this is the quote, an innocent defendant, however, usually wants a trial as soon as possible in order that his innocence may be determined and he can go free. Society also has an interest in knowing who is guilty and as soon as possible. Assuming that the guilty will be punished, society is then able to take from its midst if imprisonment is indicated or to have under supervision if probation is granted, those persons who might otherwise be committing crimes. In addition, if there's a deterrent value in conviction and punishment, as we believe there is, the swifter the punishment, the greater the deterrent. And conversely, the longer criminal discussing these rules, this is the University of, they put up the committee, the committee which wrote these rules contended that there are 2 advantages to society as a whole under a swift, efficient criminal justice system. The major goal of any criminal justice system protecting the public is accomplished by removing from society those who have committed crimes and by deterring potential criminals. The more swiftly the process operates, the more effective will be the protection of the public because the dangerous criminal is quickly removed from the streets. And that goes right along with what I said. Well, if I'm a dangerous criminal out here violating court orders, why did they wait 5 days to show up at my evidentiary hearing when they know where I live and they have 18 officers right there. They could have sent 18 officers to my house and arrested me. I'm a non-violent, no guns, nothing. So it doesn't make sense. They're doing this to this delay. There's absolutely no valid argument the state can offer, considering now that they've released the witness list upon your order, why they couldn't have released that at any point before the pretrial, upon this disclosure request, upon the order of Cranshaw, who said it had August 9th. What is their excuse for not having that same list August 9th? They had it. That was the first time a judge ordered it to them, and they blew right through it. And then I filed the motion to enforce to enforce sanctions for them not turning it over, and it got stricken. So this would have been dealt with months ago, and we wouldn't even be here. And the only reason we're here, sir, is because I wanted to catch that cop in a lie under oath so I could use it in a federal lawsuit against them. And so now, today, if this is just a review hearing, when I go home, I'm going to file the magic motions. Dismiss, sanctions, Rule 8. I don't even need to file a motion to suppress because I don't need to argue that it was unconstitutional. It was, but
He is so fucking smart.
when I do the sanctions and when I get it excluded, they don't get to appeal it as it was the standard for deciding if the witnesses should be used in the case is not the same as deciding if the evidence was gathered constitutionally, like under a motion to suppress. A Rule 15.7 sanctions motion, the standard is did they play games with the witness list? And the answer is yes. And at a bare minimum, this woman sitting next to me should be moving to dismiss this case without prejudice right now because she knows what she's doing. But they've already, it doesn't matter to me. Set a trial, I'm filing the motions. You're gonna have to rule on them, and if you don't, there's gonna be a special action. So like and it's not like personally to you, I'll just take it to a special action, writ of mandamus. Because and I've been talking for 10 minutes and we haven't even talked about, what about my trial that was already set? And then it would just disappeared into thin air without any finding on the record. And also in the case law, it clearly says, it says, to let the judge make his own record to justify the continuance of a case, especially if it is occasioned by the state of his own calendar.
This is what?
That'd be like,
I'm gonna show
the judge is required to say why he called it a conflict of interest. Well, how is it a conflict of interest?
I'm never gonna show him all.
Trial. So, upon appeal, upon special action, whatever, that record that's sitting in front of you, Your Honor, is going to need to explain why my trial that I already signed a trial thing for was vacated, and neither the state nor I moved to vacate it. And under Rule 8.5, it's very, 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 very clear. So we can go through all this, and it's going to get dismissed as anyways. And that's why this prosecutor's just barking up the wrong tree. She's going to get a misconduct charge because she will not get this conviction. And the more they try, the worse they make it for themselves. I can pull that out at any time. I'm just trying to get an interview with the cops so I can use it in a deposition and put them all over YouTube. But at any time, I can pull the motion out for Rule 8.5, continuance of a trial without Arizona Supreme Court approving it. And you were the the presiding judge for years. You know this, sir. You know, once that trial date's locked in, you gotta wipe if it comes up with a conflict on the schedule, if somebody's got a pretrial or something, well, that pretrial's getting canceled, not the trial. The trial of a defendant on a speedy trial right proceeds, has more precedent on the calendar. That's the most important date on the calendar is a trial. So if a trial is already scheduled, why was it taken off the calendar? And then, and we already went over this at the other hearing, and I got the state to admit, because even you started down that path, that saying that I moved to continue the trial. No, I didn't. No, I did not. One day we woke up and Crenshaw emailed me saying your trial is canceled and you're going to a new judge. Now, he didn't put a single finding on the record saying it's a conflict of interest. And all the case law says, all the way up to the Supreme Court with concurring and dissenting opinions, that if it's going to be on the court's order, the court needs to articulate for the record why they found extenuating circumstances to continue this trial date. The trial date should not have been continued without a motion, without a hearing, without something. And if he wants to claim conflict of interest, you do that before the case starts, not after. And I've read all the case law, even though I'm incompetent and mentally ill. When I'm on my meds, I can go and look at Westlaw like everybody else. I'm sure they got Westlaw. And it's in big letters on there. All you got to do is you just type in little words and it pops up. So I don't know if you guys need to learn how to use Westlaw. I can make you a video. But you put your subject in there and then the case law pops up and it says that under no circumstances can my trial be continued by the court without the court putting on the record why and saying it was a conflict of interest is not going to pass the test. That doesn't articulate to the appeal court or to either party. Just saying it's a conflict of interest is not articulating the position of the court. It's a conflict of interest. That's not extraordinary circumstances because you could have kept the trial date with a different judge. And that's where it really comes down to. So I got them all different ways boxed in, sir. Because if you want to rebut me and say, well, and I'm saying, well, you got 15 judges here. The trial date should have stayed this. Okay, Crenshaw doesn't want to do it. No worries. This trial date stays the same because that's locked in. If the court, Tucson City Court, wants to change my trial date, they need to find a different judge available on that day, or they need to present a healthy-ass argument on the record for future appeals why they didn't give me a different judge on the same day, why we're sitting here a month and a half later, past the trial date, and I just got the witnesses. So the August 9th deadline was supposed to be for the first trial, and they still didn't follow that. So we would have had a trial, and you get what I'm saying? They ignored the witness. We had a trial date ordered, sir. Right now, we don't even have a trial date. I'm sure we're about to get close to that. And so, the last hearing, when you ordered them to turn over the witnesses, we still didn't have a trial date. They've been ordered to turn over the witnesses with a trial date and didn't do it. It doesn't get more blatantly feet dragging and obstructionism. That's gaining a tactical advantage, harassing me with litigation, harassing me with an injunction for harassment. You want to know who interfered with court proceedings that day, sir? And I think you should be able to give him contempt. The U of A police interfered with court proceedings that day, not Lane Myers. I drove down Speedway. They interfered with court proceedings, but I went to jail. Literally had to go sit in jail instead of my hearing, and they're going to claim we had nothing to do with it. Matt Walker had everything to do with it. Matt Walker's wife got the injunction. They realized that you weren't going to help them because you're not going to violate my rights. You're literally the judge that said it's okay to record in here too, and they tried to get me arrested for recording in the prosecutor's office, but we'll keep it on track right now. We can address that. This is the judge that made 50-4 right here. They literally served me something saying that I can't come to the prosecutor's office without permission and I can't record, when literally Judge Riojas in June of 2019, because of certain people right here, made a court order saying there's certain places you can record. You signed it. They tried to say that they would have you taken to jail for doing it. And so you can't tell me this isn't harassment by, they literally had a process server come to my house to serve me a piece of paper that said, you can't come to the prosecutor without calling ahead an hour. And if you record, you'll be taken to jail. Even though I'm showing them the order signed by you in 2019 saying non-court, in the court, 5th floor, not included in the order. But, you know, they make up their own rules, and that's where we're at. There's no legitimate argument. First of all, going back to our original call, they arraigned me on 1329.043. Fighting words, disorderly fighting words, the third, right? And then they tried to, at the last second, slip in this amended thing to try to say, now we want to charge you with the general statute. Well, that's that's even worse, because that was their only chance. So they went from the only thing they could even attempt to accuse me of to, what are they going to say? I was talking loud by standing there silent? What are they going to say, that I was trying to fight somebody alone in the parking lot? Was I fighting the different subsections? This is a desperate attempt, and look what they did. They brought in these two fall women, fall ladies, for lack of a better term, the fall guy, right here. These are supposed to be the Matt Walker. He quit. He filed a motion saying I'm mentally ill, and the reason he said I was mentally ill, his statements were in their 47-page motion that included one statement of case law in the footnotes. They needed 47 pages to put one citation of case law in the footnotes. But it was 47 pages of Matt Walker saying, I don't like this guy's making fun of me, all this. And then he didn't even make it 7 days before he resigned from the case, so he's not even here to argue his own motion. So he believes so much in his own motion that I'm mentally ill and crazy, saying I'm not a mental health professional, but I've been dealing with this guy and he's incompetent. Even though he's caught me in every trick in the book. He's incompetent. And now where's he at? Matt Walker, he's gone, right? Where'd he go? Suddenly he disappeared the same day I violated the order and they arrested me at court. And now, you're not allowed to make those accusations, but I sure am. You know what I mean? You're just supposed to sit up here and take it all in and make a thing. But how can this woman, right, who's been on the case for a week, a day, 3-4 days, this is her first hearing, she came here last week magically. They didn't tell me she was the prosecutor. They won't even give her your email. They set up a special email to communicate with her. Okay. And so, because she's worried about people emailing her telling her that she's committing misconduct. But anyways, that's a different thing. And so, how can they argue? Even this prosecutor, what is she going to come here and say, yeah, my colleagues are dumbasses and they violated five disclosure deadlines, but Your Honor, we really need you to please, can you really let us violate the court rules and state case law, Supreme Court case law, federal case law, the Sixth Amendment? I haven't even confronted my witnesses. We're fucking almost 180 days, and I've made multiple attempts. I haven't even been able to confront the witnesses against me because they keep playing games. They literally had me arrested in lieu of confronting the witness. And so, what can they possibly say? I mean, we know. They're allowed to give their side of the story. But how can you argue your way out of 5 disclosure deadlines with the same evidence that was there the day you arrested me? They're claiming we're going to call the people that we knew who we were going to call the day we arrested you. We just waited 5 months to tell you, so you couldn't prepare your case. You couldn't do any interviews. You couldn't do any research. You couldn't do anything because we're just going to string you along and not tell you who the witnesses are and make you the incompetent moron, keep filing motions, and keep hoping the court's going to uphold them. But we all know that if I go in there and act crazy, the judge is going to deny them. But then they found Judge Riojas, a man of honor, who said, listen, he's making arguments, all that other shit, I've seen it all. Granted. Now suddenly, now I'm dangerous because I got a judge to agree with me, and now I need to be committed to the mental home because Judge Riojas granted my request in court. And so I think we should be in the same cell then, sir, because like if I'm crazy, you're crazy. So you could have declared me mentally ill right there. You could have said, sit down, shut up, this guy's incompetent, all that shit. You've seen it all, sir, 25 years. You've seen these games. I'm mentally ill for a week. And then when I filed my rebuttal to their mentally ill motion saying you guys violated the 47 pages, you're only allowed to file 11, there's not a single case law, and they came back and said, well, your motion in response is 12-point font and it's supposed to be 13. Well, pro se has a more liberal standard, first of all. And second of all, they went from arguing that I was mentally ill to arguing the size of my letters because they were worried their motion was going to get quashed because they didn't ask for leave to extend the limits. They're 30 years in the game. You know if you're going to... I have federal lawsuits going. Anytime you want to exceed a limit, you have to file the motion for leave with the motion you want to exceed the limits. Not wait a week and a half for me to respond and say your motion violates the deadlines, and then you respond with, well, I know our motion violates the deadlines, but so does his. Or excuse me, ours violates the deadline, the page limit, but the font isn't the right size. So we went from this arguing about if I'm crazy or not to arguing, did they seek leave and did I file the right font size? So is this a criminal prosecution or a game? And, I would love to see this woman come up here and tell the whole world their excuses why they violated 5 times and still think their witnesses should be allowed to testify. And on top of that, I'd like to hear her explain how the whole world has watched a video of their lying witness multiple times, lied multiple different times. I'm going to play a video of their witness lying in the own body cam multiple times. So what is their legal strategy? Put a lying witness on the stand, hope they can persuade you to give me a guilty verdict, and then force me to fight it on appeal? It doesn't matter. The record, sir, you've been here a long time. I've already won this case on the record. I have motion to compels that were granted and not filed. I have Rule 8.5 that was violated. I have another rule for sanctions I'm about to file because they didn't give me because I was waiting to see when they gave me the witness list, if they were dumb enough to give me a witness, not dumb enough, they're not dumb, but they're just incompetent enough to give me a witness list that didn't have, now, we both know, sir, there's one get out of jail free card with delay in the witness list. And that's saying, we were looking for this witness, we couldn't find him, we had to find him, this witness is key to our case. This is the witness, the eyewitness. And the reason it took 4 months is because we had to go out and find him. We couldn't find him. That's the only get out of jail free card for not meeting disclosure deadlines. Is that you can honestly make a good faith argument that you were trying to find the witnesses and couldn't. No, they gave me the witness list, including the arresting officers. So there's no reason. They knew who the witness list was. I have a recorded phone call with her right here on June 6th saying who the witness list was, but they never filed it. They never filed it officially with the court like I did. You know me, 15.2b, 15.2c motions, disclosure, must be filed with the court. I can't just claim that I did it. I had to file it with the court. It's on the record. All my shit was filed. Theirs was not. They didn't. Look at the record. Compare the record. Compare what I filed. Compare what they filed. They didn't file shit. I filed all my motions timely along, and then we get down here, and all of a sudden they're worried about losing, and they start filing. Their first motion was he's mentally ill. He's incompetent. Now here's our witness list. They have no foot to stand on, and if she doesn't stand up and say that
boy's in jail right now for 5 days
she's getting
for
herself
us.
in a whole pile of shitstorm. So go ahead and let her fucking make these excuses.
She ain't got one.
He was respond.
Judge, I did want to just correct one misconception. There were four officers were here on the 22nd of October, sitting in the jury box. One of them was not in uniform. The other 3 were. Sergeant Deloria was the person that was not in uniform. There was only one person in here that was not a member of the state, or the court, and that person was sitting right in that direction.
Objection, Your Honor. The arresting officer was outside. She's already started out with a lie.
Where the gentleman is sitting with the red shirt. That witness did record the hearing and did seek permission from the court to do that. I do know that Mr. Myers filed something saying that it sounded like he wanted to retroactively get that recording approved. He wanted to have.
Nothing retroactive. That was for today.
For October.
She's.
It's dated October 26th, but it refers to the October 22nd hearing. So I have no objection.
Refers to today. October 26th, I said I was going to be recording today. I can't let her just ramble on a bunch of bullshit. Come on, dude. Everything I said was true. She literally just said 4 lies in 30 seconds.
Judge, may I approach? And I'll show this to Mr. Myers. This is a copy that we received.
We don't fucking
Or
around.
what? Yeah, let me approach. Look,
No, Mr. Myers,
I accidentally, look, you got it right here, right? See this? Because I know she got it, because I know I got a response. This is my recording motion, right? I had one for last hearing, and all I did was change the date on my computer last night, and I accidentally did change that to a 6.
Correct.
This was about today's hearing. And I had one in last week, too. So think about it. She was supposed to stand up and say why. Yeah. She was supposed to stand up and tell us why they violated the disclosure deadlines, and she's arguing about recording in the court, which is allowed. It's all being recorded. I can literally get it. You guys are recording, so what's her problem? I can order it.
I agree.
But you see, I just made all these arguments, legal arguments, case law, evidentiary, disclosure deadlines, all this. She stands up and says, Your Honor, last week somebody in the crowd was recording that has nothing to do with Lane Myers.
She's making her record like you're making yours, okay?
Thank you, Your Honor. And I have no objection to the recording today.
So now tell us how White violated the deadline 5 times.
Sir, sit down, please. Mr. Myers.
Thank you, Your Honor. And just for the record, there were 4 police officers here on October 22nd who were sitting in the jury box, one of which was Sergeant Deloria. He was in plain clothes. The other 3 were in uniforms. But they were here at 9 o'clock, ready to go to hearing.
I remember there were 4 officers.
The officer that arrested me was standing out there when I got arrested. When I got taken into custody,
All she has control, sir, is TPD.
I'm saying TPD was out there, sir. The officer Devin Jamerson, Casper and Jamerson, the officers that arrested me in this case, were standing out there and they walked me out to my car. So how could they have been sitting in here and walked me out to my car?
I thought there were 4 officers sitting here.
And then what? They got up and went out there to.
I have no idea what that.
Well, she explain it. She just said, sir, we have it on video.
The bottom line is, what difference? One way or the other.
I have video proof. She just made a false statement.
Let's deal with the case.
Yeah.
Let's deal with the case.
Look at her. She's got her dusty ass law book out.
Just-
She's literally holding
let her speak.
a law book.
Let her speak, please.
Thank you, Your Honor. I think that the first matter that we do have to address is the Rule 11 that was filed by one of the prosecutors. And if the court finds that there is no reasonable information to send it to Superior Court, if that's the court's ruling, then I'll proceed with the other matters in the case. But the state submits on the written motion, the state does not plan to do any argument on that Rule 11 motion.
Mr. Myers, let's deal with the rule of the motion only, okay?
Yeah, somehow I filed all my. Check the record.
Just the rule of.
No, I know, I'm saying, right. I'm making my arguments for it. So we're having a little oral argument on the Rule 11, right? Check the record, sir. My record, right? If I'm so incompetent, because remember, the standard that we're going for here, because you can be mentally ill and still go to trial. You can be incompetent and still go to trial, right? The standard is, am I so mentally ill and so incompetent that I don't know what's going on right now? I don't know the charges against me. I don't know how to defend them, right? Okay, so let's see. From day 1, check the record. Who's been filing motions from day 1? I'm literally litigating cases at the circuit court level of the federal court system. I just won overturned summary judgment in the 6th Circuit Court of Appeals for Federal. How many times has this woman argued and won at the appellate level of the federal court? We know, none, because she's been here 30 years. But anyways, so the standard is, sir, like I said, you can be we know I'm not mentally ill, we know I'm not incompetent, but their argument is that they don't like my legal strategy. So it's not that he's mentally ill and it's incompetent. we just don't agree with how he defends this case, because normally we go sit in a room and offer each other plea bargains, and the person acts scared, and they're like, hey man, what can I do? And they're not used to somebody who's in it, because the system, sir, we know, the system's not set up for somebody who's innocent to defend themselves, because you're not supposed to be defending yourself if you're innocent, which is why she's going to be under misconduct suspension, because there's no probable cause. MRPC 3.8, oh wait, can I start quoting case law and all that? Will that make me look incompetent or mentally ill? Okay, so the MRPC 3.8, I'm not even in the bar. Model rules of professional conduct. You two are in the bar, I'm not. 3.8, special responsibilities of a prosecutor. First one, not move forward with a case that lacks probable cause. First rule of Arizona rules of conduct for prosecutors, this is misconduct. If you violate rule 3.8, move forward without probable cause, you're in violation of the Arizona rules of conduct. So that's literally a misconduct complaint already with the bar. And so you want to go over the rule 11, their argument is they don't like me and they don't like how I'm going about this, but even in their own motion, no less than 3 times they say, I realize I just made 3 pages of arguments and they have nothing to do with him being incompetent, but could you please pretend they were? And then at the bottom, they got really desperate and started saying, it was basically to see if you're incompetent, sir, saying, well, then he came to court and you allowed him to talk like that and make those arguments. And so I should be declared incompetent and have my 180 days that I've been banging the table for. That now we could see if they were sitting here saying, yep, we met our disclosure deadline, we turned it in by the first pretrial, we filed this, we're sitting here over here on our high horse going, look, man, we met every deadline, you're over here, you haven't turned in anything, you haven't met any disclosure, you haven't had to order me to do anything. It's been them. So how is the incompetent moron mental ill? And it's not even, I don't even like saying that because it's not even something to joke about. Because like there are people, this is supposed to be a serious thing, this mentally ill and mentally incompetent. This is not supposed to be a legal tactic, a trick that you try to play to end the 180 days and then put the case in limbo, and now we can just wait a while and then disappear the case and dismiss it without, no. The argument for mentally ill should have been made months ago. They didn't make it after the first hearing, second hearing, third hearing. They didn't say I was mentally ill until you granted my shit. And then their argument for me being mentally ill is they don't like my legal strategy. I've never been to a mental health professional on any care, nothing. I have a Westlaw account, and I make legal arguments in court that win in federal court. And what's funny is, I should have brought it today, is you, sir, at the last hearing, you said that they can't stop me from posting on YouTube. I have a court order from a federal judge saying the same thing. This isn't you should know, sir, this ain't my first time being, he's crazy, anything, because now, no, my arguments are dangerous. I have valid legal arguments on the record, so now I'm dangerous, so now I gotta be declared incompetent, and we both know, sir, they're gonna go over there and say, this guy's not incompetent, go back, and now what? They're gonna say, start the 180 again, all that. It's just delay. It's feed-dragging obstructionism. It's to gain a tactical advantage. If they were so worried about me being incompetent, after the first hearing with Crenshaw, why did he set a trial and have me sign something to represent myself at trial? Why did they say, sir, we can't set a trial, this guy's incompetent. We don't want to get in trouble for prosecuting a guy that's mentally ill and incompetent. Your Honor, we're gonna need to go over this. Like, we don't know if he's incompetent enough to. No, I was competent enough to go to the pre-trials, have trial, have all that shit set, file all my motions. My record reflects like a high-paid attorney. Every motion was filed on time. It was making the right valid legal arguments. It includes case law. It includes procedure. They've got nothing on the record, but he's mentally ill. How does that show I'm incompetent? I've been doing nothing but valid. How can an incompetent person stand up here and quote case law from the Arizona court, model rules of professional conduct from the Bar Association that I'm not even a member of? I'm not even required to know them, but I know them because I filed complaints on it. And so, you know, how case law, procedural. She's literally got her dusty ass law book, and I'm reciting it off the top of my head, and I'm supposed to be incompetent. I don't even got my phone in my hand, nothing. I literally have, everything I just said to you though is right here. Like, I literally have all of my arguments right here, see? I come prepared. You notice I don't have a law book? I have arguments specific to my case that include case law from Westlaw and arguments, how to, here's that letter.
I've seen that. I have.
Yeah. You got it? You know what I mean? That says, Riojas' court order 50-4, fuck that court order, we'll do what we want. And so, you see what's going on. That makes you, so they put that on the record, that's how stupid they are? Or incompetent, excuse me? Yeah, because here's your court order right here, signed by Mr. Riojas himself, saying that what I could do is, so they're trying to paint a pattern of me being crazy, coming up there and doing all this, not mentioning the fact that I literally read your court order that said I could go up there, and I went up there. So how could I restrict my behavior to not be known as incompetent if I'm following your order? See what I'm saying? So I think you understand, you know, I mean, I think you know, I don't need to sit here and talk for 30 minutes and talk in circles. I'm pretty sure that I'm not incompetent or mentally, and anyways, they haven't even met the standard. They weren't even arguing I was mentally incompetent. They were arguing I was an asshole.
Anything else to say concerning the rule 11?
Just that, will the state grant our motion to exceed pages so we have a full record, no matter what the court
I'll
rules?
grant the motion to exceed page, and I'll also deny the rule 11 motion. Mr. Myers may
Thank you, sir.
now, please.
He denied the motion for incompetence like a man of honor. Thank you, sir. We can all see what's going on, and they said they didn't want to argue it. Think about it. They filed a motion. You already denied it, so I mean, how much do you believe in a 47-page motion that you come to court for oral arguments and don't even make a statement on it? You know you're committing misconduct. Don't make excuses for him, sir. We can move on.
Judge, the state did not request oral argument on the Rule 11. The state submitted.
Because you knew it was nothing more to waste time and make me file motions in response. It was nothing more than...
Thank you, Your Honor. The court's ruled.
Rule 11 has been denied.
Thank you.
And the state has some things to say about the procedure to go forward next, but it depends on if you want, the reason why we're here for the hearing.
We're here for the hearing because you have me arrested. What happens to that 7 days, sir? I mean, I can sit here and put on the record that I was unlawfully arrested, you know what I'm saying? So, I appreciate you not moving forward, and I believe that you erred on the side of caution, and I just want to get on the record. You could have moved forward. You could have had that Rule 11 without me there last week, and I'm glad you didn't. Thank you.
The state does want to be heard on setting a trial within Rule 8 time limit.
The trial was on September 30th. It was already vacated. There's no, you don't have standing to start a new trial.
We are, Judge.
We do.
What are we gonna do? Have a trial with no witnesses?
We're not there yet.
Thank you, Your Honor.
Yeah, no, I feel you. Set the trial, and then I'm gonna file the motion today, and then, yep.
What is state, what are you saying?
So Judge, we've done a couple of calculations. The state would submit that the time between September the 18th through October the 22nd, while the court did not note it on its minute entry, should have been excluded because it was for the defendant to conduct his interviews as well as file a motion under Rule 16 for suppression. He did mention it in the hearing. I did listen to that hearing. He said he was going to file a motion for suppression. He wanted to interview Sergeant Deloria first, and the court gave a deadline of October the 11th to have that interview. That did not occur.
It's called a legal strategy, Your Honor. You don't get to hold it against me. These are the most desperate, sad arguments, sir. Okay. I'll try not to laugh.
So 15.3 was clear and was actually provided that there are certain ways to subpoena a person that either side wants to interview, and it does not appear that that procedure was followed. The state did check with Sergeant Deloria, and he did not receive and was not served under 15.3.
What does this got to do with the time limit, sir? She's rambling about nonsense. She's literally looking at her law book. She's not prepared today. She's not prepared.
You have your chance.
15.3C, subsection 3 reads, notice and subpoena. If the court grants the motion, the moving party, which the court did grant the motion to have the deposition of Sergeant Deloria by Mr. Myers, the moving party, that's Mr. Myers, must notice on the Rule of Civil Procedure 30B. The notice must specify the terms and conditions in the court's order granting the position, or granting the deposition.
Stop.
Yes, sir.
Under your calculation, based on your
will the court exclude the time between the 18th?
I need to argue for that first.
Based on your calculation,
Yes, Your Honor.
what is the time limit?
Judge, the time limit, if the court,
180 days from June 6th.
if
No, I'm asking for specific date.
certainly, Judge, if the court includes the exclusion of that week of time, the trial should be held by, December the 10th. It can expire on December the 10th of 2024. If the court does not do that, then it's going to expire on, December the 2nd.
They must not know math.
December the 3rd of 2024.
Sir, what's 180 days from June 6th?
Sir, stop.
If all days are included, if the court excludes this last week, then it's December the 10th. If the court does not deem to,
So you're saying the earliest rule aids deadline is December 7th.
this actually is December 3rd, it expires on December 3rd. So it should happen, and I'm not sure if that's a.
This isn't true, sir, because my court date that got switched is on December 2nd, and that's the 180th day. This is, I gotta object. How is she arguing?
You have your chance.
She's supposed to be arguing about case. She just read the case law. Where does it say that if you order a subpoena, the time is excluded? That's the dumbest thing I've ever heard.
Myers, all right.
Okay.
Thanks. You have your chance to speak, okay? Don't let her interrupt you.
Judge, it looks like it's December 2nd, that Monday, December 2nd.
That's 180 days from June 6th, ma'am.
They're killing them all.
Against the state, except for the first day, which.
Can we make some legal arguments?
So you're saying December 2nd is the
Drop
earliest, is the earliest day without any excluded time being factored?
Yeah, it's the latest date. It's the latest date that we can have the trial without any time being, if all time is included against the state.
December 2nd is the deadline in your mind.
Why at the last hearing did you say it was November 15th, sir?
Yes.
You said at the last hearing it was November 15th. I'm telling you she's gaslighting me.
Judge, the state didn't say that, the state believes that that was
The
Judge.
judge did.
The state believes that that was Judge Meehan's miscalculation, the state is.
That was Judge Riojas at the hearing with Matt Walker. We literally put it on the record that my things were November 15th. We set the thing for October 22nd because it had to be within a timely manner to have the trial within the 180 days. She's literally talking in circles from the law book. Nowhere in the law does it say that the days are excluded because you asked for a deposition. That's the dumbest argument, and you shouldn't even, I get it. She has to be able to talk, but we're wasting time, sir. Come up with an argument.
Okay, so December 2nd, December 9th, if the week of excluded time that the court legally excluded last week to this week is December 9th.
Myers, okay, so you're saying December 2nd, that excluded time being factored.
Denied.
She hasn't argued why the time should be excluded. That's the most
I'm
important.
just asking December 2nd.
Right.
This man.
But ask her
already knows
to
it.
put an argument behind why she believes this time between you ordering.
I'm saying, if I don't consider it, if I do not accept that argument, she's still.
Well, she hasn't even made an argument.
Sir, let me finish. She's saying December 2nd is the deadline if I do not.
I get it. No, we're all on the same page, but I want to hear this argument why the time between. No, you can't rule until she argues and then I argue in response. What I'm saying is she's saying that there's two possible scenarios, sir. One, we don't exclude any time and it expires on this date, and it does. If we do exclude it, it will be this date. Now she needs to sit up here and articulate how under Rule 15.3, when you order a deposition, the time stops counting. There's nowhere in Arizona State Court history where the time stops counting because the judge asks for a deposition. There's also nothing that says just because he ordered one, you have to do it. It's called legal strategy. It's called making that dumbass cop sit there for 10 days, scared as shit that he's going to have to go under this deposition, and it worked.
And Judge, I do have some more comments on why more time should be excluded if there are motions to suppress that are filed.
I'm not filing one, I don't need to.
Sorry.
We'll cross that bridge if and when we have to.
Okay, so, but if we were crossing that bridge, then, let's say.
I agree. If you
You're
file-
fucking done,
The
bitch.
state has.
That's why I'm going to file a motion for sanctions, not suppress.
Motion for suppression under Rule 16.
I'm not filing that.
That would be for the defendant's benefit because evidence gets suppressed.
I'm not doing that. Why are we still talking about this?
Just say it and then he can respond any way he wants to. I mean, as long as he wishes to respond. But under Rule 16, if there is a motion to suppress that is filed, that is for the defendant's benefit. And if it is filed, the state will have 10 days to respond to it. And that time, from the date that people are in court, the date that we actually have the motion to suppress should be excluded time, which would then push the, bench trials back.
Is this a criminal proceeding or is this a first-year law student teaching at the law school?
Okay, Ms. Brown. Okay, so see.
So what the state is asking the court to do today, at a minimum, is set a bench trial for both of the two disorderly conducts, consolidate that trials, and have an acknowledgement of trial set so that at least we have some kind of peace within the real life deadline, because the victims also have the right to speedy trial as well.
Oh, now they're worried about the victims. Ah! Fake victims.
So essentially, in terms of setting a date, we do nothing else today, we do not do anything else in terms of actually, the state is urging the court to set a bench trial date within these time limits. Most favorably to the defendant.
Oh, now they care about me.
They're asking you to set a trial.
That's fine, but we can't let him get off the hook, ma'am, or sir. Ma'am, you need to stand back up and articulate why, where in Arizona rules of procedure or Arizona case, you literally just stood up before this court and said, we believe that the time from the last hearing until the time for that should be excluded because we asked for a deposition. That's not a legally based argument.
If I use December 2nd as the deadline,
But you said it November 15th.
I'm saying now.
Are we calculating this from 180 days from June 6th?
We are she's capped at 180.
So 180 days from June 6th puts us at, you told me, this should be simple math, ma'am, can you?
June 6th is 6/6.
Right, but some of them are 29, right.
Well, we 12/6, 12, minus.
A couple days in the months are 30, 31 and shit like that, right. So so I'm trying to figure out how my 180 days on the case that I was arraigned on in July, this doesn't make, because, you remember how there was two cases, one got sent to justice court? My trial over there is December 2nd because that's the last day it can happen. So, and that case happened after this case. So how is my last day over there December 2nd, but this case, which happened 2 weeks before that, is longer?
It's date of arraignment.
Date of arraignment.
The 6th.
Won't be arraignment.
June 6th?
No, you have to decide.
June 6th?
June 6th, I believe, is the date of the arraignment for the two,
Yeah. The two cases that were before you right now,
180 days.
from June 6th.
It's early December.
Alright, okay.
So, her argument about the excluded time, unless I said something after December 2nd, then I consider argument.
Of course.
But if I don't, if I set a date on or before December 2nd,
I respect that, sir, but I'm saying that we can't let this go. I have to get this on the record for my future reasoning. This woman just stood up.
there's no reason.
She just stood up and said, Your Honor, you can't, I need to be able to have this articulated. You can't order her, but I'm asking you to ask the state where they came up with the argument that when somebody gets a deposition ordered, the 180 days start counting. She just stood up before this court and put on the record that said, when you ordered that deposition, she's asking you to exclude the time from the time the deposition was ordered to the deadline of the deposition because I didn't do it. Just because you ordered one doesn't mean you have to do it, and there's no punitive punishment.
March
You don't
25th.
It's not, hey, I'm going to order this deposition, and if you don't do it, you're going to lose a bunch of your time in the 180 days. That's absolutely ridiculous, and it should you should be sanctioned just for even saying that, because your literally dusty-ass law book doesn't say anywhere in Rule 15.3 that if you don't subpoena the officer, you lose time on your 180 days, and that's that argument is the most straw man argument I've ever heard in my life. Either I get 180 days, okay, or there's a valid reason I don't. Asking for an evidentiary hearing does not exclude your time. Asking for a subpoena does not exclude your time. So the whole basis of why time should be excluded was that I asked for a deposition.
16 years.
I'm supposed to be
federal
incompetent.
prison right now.
Thank
Not
you.
100%.
And you've already did.
No.
And
I'm definitely wrong.
December 2nd for now.
and she keeps going on about this motion to suppress. I'm not filing one.
Like I said, we'll cross that bridge.
You done heard it.
Today, I'm looking you straight in the face and telling you what I'm filing today. A Rule 15 motion for sanctions, and a Rule 8 motion for sanctions, and a motion to dismiss under Rule 16.
Then
and
you
because
gonna slap
because
their
of all
ass.
that shit
You
she
gonna
just
hit
said,
them
she
with
doesn't
the
realize
slap.
we're playing legal chess. Her
They
dusty
never
ass
seen
law book.
one with
Here's the
slap.
bottom line. If I
None
don't,
of them never
if I
seen
file
one
it as a
with
motion
slap.
for sanctions, and not as a motion for suppression,
not
she doesn't get all that
bringing
fancy
new law.
bullshit she just claimed.
For all
Because
of
a
us.
motion for sanctions does not mean that it was unconstitutional. It means you played games with the disclosure deadline, and therefore that whole it's the defendant to consider the evidence and all that shit don't apply. And I have 3 pages of case law of that right here. So she's looking in her dusty ass procedure book. I'm literally showing you cases on Westlaw that say,
You haven't filed a motion.
I know because I didn't know what today was. I didn't know. I thought we were gonna have. If today was the evidentiary hearing, we were gonna. And now it's not. Now I need to go argue this on paper.
And Judge, the state has for 10 days to respond, and when he mentioned Rule 16, if it's an evidentiary hearing on suppression, that time gets excluded, it is for the benefit.
Right, I agree.
But the state wants the 10 days to respond.
So they wanted me to get arrested, miss the hearing, and have the days.
Under Rule 1.9 and under Rule 1.6.
There's no.
There is
He's in
a-
jail.
There's no motion to suppress.
State to respond.
Right now, as we
Rule
speak.
16.
Oh.
16 is pretrial motions.
Guess what, sir? Now they want to bring up Rule 1.9 on the record before you.
Right
even
now,
though-
as we speak.
Because this is relevant, sir. We have to catch them in their own. So, she just said, Rule 1.9, they want their 10 days to respond, right? Go back to the record. They filed the motion for incompetence. 4 days later, they filed an emergency motion asking you to rule on the motion before I could even respond. And now they want to make sure they get to respond. But on the record, they filed a motion saying, can you respond, or can you rule before he even gets his 10 days to respond? And now they're saying, Your Honor, can we make sure we get our 10? So they didn't want me to have 10 days to respond, but they want to make sure you give them 10 days to respond. Yeah, we all see what's happening. The whole world knows what's going on right now.
Let's use December 2nd for now for the trial.
Okay.
What is your officer's availability in that time frame? Is there any time? What is availability?
If they're allowed.
Sergeant Deloria and Officer Javerson both are fine, there's no conflicts. Officer Casper, I think he was in on the 26th, May 26th, has many conflicts, so the state doesn't know if the state's going to call him.
I'm going to call him.
But you have to subpoena.
I will now that I know that they see, this is a game, sir. This is chess. Chess.
What they've said, if they can't, if that trial date's not available, they're not gonna use it.
Officer Bates,
Doesn't mean I can't subpoena him.
Officer Bates is not available between.
Bates isn't even allowed. That's ridiculous.
Officer Bates,
Who's Officer Bates?
Officer Bates was at one of the events, so.
Why did they listed it? Why don't I have their police report? Why don't I have their body? How did I learn about the name Bates today?
Officer Bates was on the list that was disclosed as ordered by the court on the.
But not any time in the 4 months before that.
22nd of October of 2025, I'm sorry, 2024. Officer Bates is not available from the 16th to the 23rd.
November?
Of November, yes.
No, you're gonna set the trial on the very last day, sir.
Not necessarily.
All right. Well, then you tell me what we. Okay.
They're trying to figure out what a conference is.
So those are the ones that I have. Did I say, oh, I'm sorry. Officer- Yeah, no, I haven't.
Because you said something in your minutes from last time that I didn't file no motions, right? Evidence motions. Because I was gonna walk in here and do it like they tried to pull that trick on me that day.
Fine. Is that officer, that's your only conference?
Was that, I'm sorry,
That's your only conference?
that's the conflicts that the state has.
And I assume Mr. Myers, last time you said you have no conflicts.
Well, right now I got a case. Well,
Do you have conflicts between now and December 2nd?
December 2nd I have trial. Possibly have trial at Justice Court.
December 2nd.
I have. Well, November 4th I have Michigan federal, and then so the only thing that is like the most important thing is my court date. So like I said, court date at Justice. The 2nd, I might have a court date come up for this being arrested outside the door by the SWAT team. You know, they haven't even arraigned me. When I went to the thing at Justice Court, the state needed more time to even see if they wanted to even press charges on me.
I think it's unlikely that the Justice Court will think between now and December 2nd.
Right, because the little thing they said was November 25th for it.
In either
Right,
case,
right.
if there was a conflict,
I'll
in
let
the
you-
case,
right.
you have priority because it's an open case.
That's what I'm saying.
But Judge, you did exclude the time
No.
from last week to this week, so we should have till the 9th.
No, why would they exclude the time?
You excluded the time on your minute entry. Are you reversing that?
When did you put it? Can I get a copy of it, please? The one from last week? Because you emailed, I believe she emailed it to me, and it hasn't came in the mail yet.
We don't get nothing.
Because
Any time in here December 2nd. You got no, that's it for.
How many days?
This is what happens when you're a boss. We don't
How many
know
days?
this.
No, I mean saying, how many days do we have between right now and that?
December 2nd?
Yeah.
You have about a month. give or take.
Right, so we got plenty of time to file the motion and respond, and have another status hearing if we need, but you can set a trial today. That's what I'm saying. So we have that lighthouse in the future.
So the state is.
I don't want no money from Lane.
If the court, if the ruling of the court from last week holds it being only excluded, then if the calendar gets put up a little bit for the December.
Why would it be excluded? Because I was unlawfully arrested?
From last
I
week.
just want Lane's story to be out
The
there.
argument is it was not because of what.
That's it. Not more
That's not what I
than
did
less.
either.
It's things.
But you can't hold that against me till I'm convicted at least, because you got, so they're saying that my arrest was because I allegedly did something.
Using that argument, after you're convicted, that could be another 4 or 5 months.
No, I'm saying to decide if it was excluded. I get what you're saying. Right. No, I see what you're saying. So what? They want 7 days? Take it.
Okay,
7 days ain't gonna save you. 7 years isn't gonna save you.
so if we could possibly look at the week of December,
First thing you say, include the town road.
thank you, Aaron.
So, who's he saying?
I appreciate it, I'm
We'll
sorry.
make it trial week. I'll win 2 trials in 1 week and put you under federal indictment in the same week, Mary. You know where you're headed.
No, what day are you suggesting?
Let me just.
She needs her glasses.
A Tuesday?
It could be any
So-
any morning but a Thursday.
Okay,
Any
so,
but a Thursday
so
morning.
it could be December 10th, and then if we need to go into December 11th?
Hopefully it doesn't take 2 days.
It could.
Oh, they don't have 5, it shouldn't take more than 5 minutes because we're not gonna even have trial because they're gonna get all their witnesses excluded.
So Mr. Myers, 10th and 11th?
So do we show up for trial? If I'm the only one that's allowed to show up, there's no trial, right? Because didn't you tell me no witnesses, no trial? Right, okay. Yeah, there won't be no trial, but we can pretend there's gonna be.
So we'll set December 10th as a trial.
There's a better chance of me growing wings and flying out of this courtroom than us having a trial.
At 9 o'clock, Judge, or do you want 8:30? What time do you want?
We'll set 9 o'clock.
Okay. Can we get a trial announcement?
Yeah, we'll get it.
I'm not signing it though, not to be a dickhead, but I already signed one.
Let's do it. We'll just say so.
I'll agree to be there. I'm agreeing to be there, but I ain't signing no paper for a second trial that I already signed one for.
Judge, the state does ask that we need a trial acknowledgement just in case anything happens to anybody.
It's on the record.
It's on the record,
If I don't show up, it's failure to appear. You should know that, Mary, that you can do verbal motions.
Under 9.1, Your Honor? Thank you. Just could you 9.1 advise again on the record? That'd be excellent.
So we'll set this trial for December.
I don't understand, sir. I'm incompetent.
What's she doing? She's making the record.
She's failing to save her own ass, but we all know what's happening. She's desperate. They're arguing about the size of my letters. The time should be excluded. Did they? You notice they didn't. She didn't say a single word. I talked for 10 minutes about how they were violating disclosure, sir, and that she didn't offer a verbal response on the record. And now I'm telling you, I'm about to file a motion, 11-page motion with 13-page font with underlined headlines and topics, just so that they can't complain about that. And it's going to say that they violated the rules of disclosure 5 times, and they didn't even have. We just been in here for what? An hour. We've been here an hour, and she didn't offer a single argument for the record why they felt they were allowed to violate Rule 15 and not give the disclosure as required by the law. She's got the fucking law book right there, literally, Rule 15.1, look it up. Unless they tore that page out and threw it away when they were doing Matt's disclosure to a sword. They literally, the prosecutor that has been doing the most of this case has a video on the APAC about how to do this to people, and I caught him doing it. And I used his own strategy against him, and here we are.
Let me break it down.
What I'm saying is December 10th on top of the trial.
Here comes the judge.
Allegedly.
We'll cross that bridge if and when we have to cross it.
So if
If you don't show up, I expect another fight. If you don't show up, the trial will be held without you, and we'll warrant the assurance, just so that you realize if you're not here, stuff can happen.
So is there a trial acknowledgement that can be served on him without him having to sign it?
Yes.
And can the state get a copy of that, Your Honor?
it's not going to save you, Mary.
Thank you very much.
Felony
The trial
charges,
acknowledgement is not your smoking gun. It's not your magic piece of evidence, the trial acknowledgement.
felony?
This case doesn't hinge on the trial acknowledgement. And if you want to talk about trial acknowledgement, I'll show you one that said I acknowledged the trial for September 30th.
They hit him
And
on
I'll show you
felony.
the same minute entry that said you had till August 9th to turn over your disclosure list, and you didn't. So before you worry about trial, you
You
better
got
worry
ran
about
over
how you're
on
going to get these
misdemeanors,
witnesses up
as
on
you
that
listened
stand
to.
and get them
They
past
want
the
them
Rule
felony.
15 standard, because as soon as, if he doesn't grant it, I'm filing a special action. Immediately. Writ of mandamus, straight over to Court of Appeals, and I can guarantee you this case won't go to trial. And you'll be sanctioned, and you'll be under prosecution just like April and the Maricopa County. You know what you're doing. You're violating MRPC 3.81. Special duties of a prosecutor. You cannot prosecute without probable cause. And you know it. We know it. Hey, don't we chat? Hey, the chat said, thank you, Your Honor.
You're locked up for felonies, motherfucker.
The chat said, Mary, you're gonna get a lot of phone calls.
You're
and
in
emails.
jail right now.
I wonder if
Just a second. According to the notified